Good afternoon, and very good to have you all here. It is my great pleasure to welcome you all to this academic ceremony of Maastricht University. And I do so in my capacity of Dean of the Faculty of Law and representing the university as Pro-Rector. Wonderful to see that so many of you have found their way to our aula or are participating in this ceremony online. Also very much welcome for those of you watching through our live stream. You are all here for a very special occasion, the official installation of Professor Maja Brkan to the chair of Digitalisation and EU Law. And I welcome all family, friends and colleagues of Professor Brkan. And I welcome the large delegation from Luxembourg representing the European Court of Justice and the General Court. Delegation headed by Professor Mark van der Woude, whom I also very much welcome to Maastricht. In a few minutes, Professor Brkan will officially accept the chair by giving an inaugural lecture. Before I ask her to come forward, I just would like to say a few more words about Maja, allowing me to explain why it is that our faculty and university are truly happy with her appointment. Maja, few people are as all-round and talented as you are. After your bachelor in Ljubljana and a master at New York University, you defended your PhD in Slovenia in 2007 on the EU Common Foreign and Security Policy. A PhD that you prepared in less than 2 years. You then worked at the EU Court of Justice in various roles, including working for Judge Marko Lesic. In 2013, you came to Maastricht to teach at our Faculty of Law, where you took up the role of Associate Director of the Maastricht Center for European Law and became the coordinator of the Advanced Master in Privacy, Cybersecurity and Data Management. To be appointed as a judge in 2021. That was a great success for the court, but less so for us. So we are very happy to have you back now with us here at our university for 1 day a week. Now, Maja, this is truly a success story. But the question is, what is in fact beyond all these titles and successes? Beyond the court cases and the publications? Luckily, as many colleagues present here at the podium know, I have always some spies who tell me about our new professors. People who keep a close eye on you. And they told me about your drive, your talent to organize things, and about many other things. Talent to organize things also in your own family life. And your ability to elevate others around you. And allow me to quote only one of these spies. She told me, and I quote, "Maja has passion and resilience in whatever she does. When working, it is close to AI efficient." I like that, AI efficient. In line with the perfect schedule of an early riser and an equally early rester. Now, dear all, in the case of Maja, we should not take resting too literally. It tends to consist of swimming 5 miles from the middle of the sea to the shores of Turkey, of skiing in the Alps, of practicing Tai Chi on the Canary Isles. Of course, that's only when you do not play the guitar or visit the opera, while at the same time supporting your female colleagues and striving for equality. In short, we are truly delighted to have you back with us here for 1 day a week. Professor Brkan, I now invite you to give your inaugural speech entitled Digitalisation and EU Fundamental Rights, the Good, the Bad and the Opaque.
Thank you very much, Pro-Rector, for your kind words and for welcoming me back to Maastricht University. Digitalization is omnipresent and is already entering all aspects of our lives. However, few technologies are revolutionizing the way we work and live as much as artificial intelligence, and in particular, the generative artificial intelligence. Generative AI tools such as ChatGPT, DeepMind, and AlphaFold are increasingly being used to generate or to create text, images, and videos, such as this one, which was created by Sora from OpenAI. By the way, I love Tokyo, that's why I have chosen this video. But these technologies are also used for scientific research and even decision-making. And whenever decisions are taken with the help of artificial intelligence, they can have a profound impact on our fundamental rights. And therefore, in this lecture, I will argue that we can only enforce these fundamental rights if we understand why a certain decision was taken. So my main argument will be that the scope and the content of such an explanation can either foster or hinder an effective enforcement of certain fundamental rights. And as a background for this research, I will rely on an example in which the use of generative artificial intelligence that is integrated in high-risk AI systems impacts selected fundamental rights. Now, I know this sounds very sophisticated, but let me explain. So generative AI is, simply speaking, a technology that is used to generate new content, such as text and images, such as this one. So I might swim, but I don't actually surf. This is obviously a deep fake. Or videos such as this one. This video hasn't been videoed, hasn't been filmed, but it has actually been generated by generative AI. And this technology can also be used as a support to take decisions. But if generative AI is used for taking decisions, it is very difficult to understand the reasons for such decisions. And this is because generative AI uses machine learning models, so-called deep learning models, that are able to take very complex decisions in a roughly similar way as a human brain. And computer scientists in this room know that I am simplifying a lot. Secondly, high-risk AI systems that are regulated in the recently adopted Artificial Intelligence Act of the European Union are, simply speaking, those AI systems that represent a high risk to the harm and safety and health and fundamental rights of the persons. For example, a high-risk AI system is an AI system used by a university that helps to decide whether a person will be admitted to education. Or an AI system used by an administrative authority, deciding whether someone will get a childcare benefit. And finally, it is common ground among scholars that the decisions taken by such high-risk AI systems can impact fundamental rights, particularly if they use generative AI. The fundamental right to data protection can be affected because such systems use a large amount of personal data that is not always collected and processed in conformity with data protection legislation. The fundamental right to non-discrimination is among the most affected fundamental rights. For example, if such a system systematically chooses male over female applicants in a job application process. And finally, if a person doesn't understand the reasons behind the decisions, he or she will also not be able to bring a claim in front of the court, thereby affecting his or her fundamental right to effective judicial protection. So I will be looking into the intersection between these three domains. And within that intersection, I will address the following research question. How do the scope and the content of the right to explanation impact an effective enforcement of these three fundamental rights? The fundamental right to data protection, the fundamental right to non-discrimination, and the fundamental right to effective judicial protection. Now, this research question is also reflected in the title of this lecture. The good symbolically refers to the right of explanation. The bad symbolically refers to the negative impact of this technology on fundamental rights. And the opaque refers to the fact that algorithms used in generative AI are often opaque, non-transparent, which makes it difficult to understand the reasons behind their decisions. However, a lecture discussing these topics would not be complete without the help of generative AI itself. I will therefore let Sarah introduce herself. Sarah, please.
Good evening. My name is Sarah, and I come from Spain.
Good evening, Sarah. So, Sarah is an avatar created by a combination of 3 tools: ChatGPT for picture, Hagen for animation, and Synthesia for her voice. While I have prepared the text that she speaks, the visual was created by Jaka Ciglic from the company Vebio. So obviously, Sarah is not a human, and any resemblance with an actual person is a pure coincidence.
I respectfully disagree. Of course, I'm a human.
And as you can see, she has a will of her own. So Sarah, could you please tell us a bit more about yourself?
Sure. I'm a PhD student at Maastricht University, researching the impact of new technologies on judicial decision-making. Maja is my PhD supervisor, so I pop by to see whether she has something smart to say.
Thank you, Sarah. So why are you with us today?
I'm in trouble. I have applied for an Erasmus exchange because I would like to spend a semester at the University of Ljubljana in Slovenia as a visiting researcher. But Maastricht University refused my application. I do not understand why.
I'm so sorry to hear that. Do you perhaps know how this decision was taken?
Yes, Maastricht University informed me that the decision was taken with the help of a new program called GenAsmus, powered by generative artificial intelligence. It is a new tool used by university that helps to decide who is accepted for an Erasmus exchange. And can you imagine? It also generates explanations of these decisions. Can you perhaps help me?
Sure. Let's look at your situation from a legal point of view. So regarding the legal analysis, Sarah's problem raises the following legal issues. First, does Sarah as an avatar have legal personality, and can she even rely on rights? Secondly, what is the scope and content of her right to explanation of this AI-based decision, the decision taken by the GenAsmus system? And third, how do the scope and the content of her right to explanation impact the enforcement of the following fundamental rights? The fundamental right to data protection, the fundamental right to non-discrimination, and the fundamental right to effective judicial protection. So does Sarah have legal personality, and can she actually have rights? This highly controversial question of legal personality of AI systems has been widely debated in legal and philosophical doctrine. The most cited arguments in favor of legal personality of AI are the following. AI systems already participate in public life because humans entrust them to make certain decisions. Furthermore, granting legal subjectivity to AI could prevent scattering the liability between different participants in the AI supply chain. Moreover, relocation of liability from developers and deployers to AI systems themselves could encourage investments in AI, seeking the AI to be more accurate. And finally, legal subjectivity of AI could only be limited to certain domains when it is justified by their social roles. However, there are also strong arguments against endowing AI with legal personality. First, AI systems do not have the ability to understand and make moral judgments. They lack consciousness, self-awareness, and moral agency. Furthermore, transferring the liability only to AI systems could allow humans to evade liability. Furthermore, AI systems are not truly autonomous, but rather act on the basis of complex computations. And finally, recognizing legal personality to AI systems might blur the lines between humans and machines, and therefore raise numerous social and ethical dilemmas. And even though the question of legal personality of AI systems is extremely complex and would deserve a lecture in itself, I'm personally rather skeptical as to granting legal personality to AI. It seems to me that if such a development were to take place, this new form of legal personality would need to be clearly defined, delimited, and distinguished from legal personality of humans. Therefore, in my view, the arguments against legal personality at this stage prevail over the arguments in favor of legal personality. So, coming back to Sarah, I'm sorry, but it might be rather difficult for me to help you with your case, and my analysis could actually stop here.
I would have expected a better job from you. Can't you think of another solution?
I can try. We can work with the legal fiction.
That sounds sophisticated. What does it mean?
Simply speaking... Oh, sorry. See, she's a bit ahead of me. So what I'm trying to explain her, and she just jumps in my word, is that legal fiction means that we could actually try to solve her case as if she was a human. And she seems very excited.
That sounds excellent. Well, regarding my human capacities, allow me to point out that generative AI systems have already passed the Turing test. The Turing test measures whether a machine can behave in a way that is not distinguishable from a human.
That is true, Sarah. Scientists claim that earlier this year, the ChatGPT-4 generative AI system has indeed passed the Turing test. So let us apply the legal fiction and see how your case would be solved if you were a human. In order to do that, let us look into the following question. What is the scope and the content of the right to explanation of the AI-based decision? So what is the scope and the content of the rejection of her Erasmus application? So Genasmus, the AI system that is used to decide on her Erasmus application, clearly falls among the AI systems used for admission to educational institutions, as defined in Annex 3 of the AI Act, and can therefore be qualified as a high-risk AI system. For these type of systems, Article 86 of the AI Act provides the right to explanation. This article states, any affected person subject to a decision which is taken by the deployer on the basis of the output from a high-risk AI system, and which produces legal effects or similarly significantly affects that person in a way that they consider to have an adverse impact on their health, safety, or fundamental rights, shall have the right to obtain from the deployer clear and meaningful explanations on the role of the AI system in the decision-making procedure and the main elements of the decision taken. Now you can see law can be very, very complicated, but I will try to break down this provision for you. And if we apply this provision to the case at hand, we can see that there is a decision, so the rejection of her Erasmus application. This decision is taken by the deployer, Maastricht University, on the basis of the output from the high-risk AI system, so the Genasmus system. We can also provisionally conclude that this decision significantly affects Sarah in a way to have an adverse impact on her fundamental rights, and I will talk on her fundamental rights a little bit later. And that therefore, she has the right to obtain from the deployer, from Maastricht University, a clear and meaningful explanation. On the basis of that provision, we can also conclude that this explanation is twofold. On one hand, she has the right to obtain the explanation on the role of the AI system in the decision-making procedure, and on the other hand, she has the right to be informed about the main elements of the decision taken. So, on the one hand, the role of the AI system in the decision-making procedure seems to suggest that Maastricht University would need to explain whether in the decision-making process it relied exclusively on the output of the AI system, or whether the final decision took into account also other factors, such as, for example, an interview with a candidate, a reflection of a human decision-maker, or perhaps additional documents, such as certificates on the language proficiencies that were not part of the input data analyzed by the AI system. And let us suppose that Maastricht University indeed relied exclusively on the output of Genasmus without human intervention, because I cannot imagine that a university which is as international as Maastricht University would reject the applicant, such as Sarah. But we are still going to get to the bottom of the reasons why. So let us suppose that they have used only that artificial intelligence system to reject her application. So on the other hand, the phrase, the main elements of the decision taken, is a bit more tricky to interpret. For the purposes of this lecture, I will look into 3 alternative possibilities as to the interpretation of this phrase. But of course, in practice, there are more than 3. The first possibility is an explanation that gives information about the criteria for decision-making and the weights attached to each criterion, the input data regarding the applicant, and the training data on which the algorithm was trained. The second type of explanation is an explanation that shows correlations between different variables that were established in the dataset during the self-learning phase. And the third type of explanation shows the interdependence between variables. For example, during the self-learning phase, some variables could be awarded higher weights than others, so the weights of variables can actually change in the self-learning phase. And to discuss these three types of explanations more concretely, I will look into the question, my research question, on how the scope and content of the right to explanation can impact the enforcement of certain fundamental rights. And let me start with the fundamental right to data protection. Regarding the fundamental right to data protection, I will look more into detail of the first type of explanation. So in the case of Sarah, this type of explanation could look something like this. Because you only speak one foreign language, English, you were not accepted for the Erasmus exchange. And let us say that the following information would be added. The system relied on following variables: grades for 30%, knowledge of foreign languages, which counts for 50%, and the letter of motivation, which counts for 20%. And perhaps the following information could also be added for your information. The training data was composed of Erasmus applicants in Belgium, Netherlands, and Luxembourg. But let us first ask Sarah what she thinks about this explanation.
This explanation contains incorrect input data. I do not only speak English as a foreign language, but also Slovenian, which I have recently started learning.
Oh, really? I didn't know that. Can you perhaps tell us something in Slovenian?
Seveda, želim si obiskati Slovenijo. This means I would like to visit Slovenia. Can you perhaps help me so this dream comes true?
I can try. So what Sarah can do in practice is to request Maastricht University to rectify this error in the input data, invoking Article 16 of the General Data Protection Regulation. That way, Slovenian language would be added as a variable in the input data. And we can see that the enforcement of the fundamental right to data protection will mostly concern the input data. So questions as to how the data is collected, what is the legal basis for the data processing, and is the input data accurate? It would therefore not really be necessary to understand the correlations and the relationships between different decision-making criteria. And it seems that this first type of explanation will be sufficient for the enforcement of this fundamental right. However, since the fundamental right to data protection is given expression by the General Data Protection Regulation, we should also examine the question whether Sarah could, in addition to or instead of her right to explanation from the AI Act, rely also on the right from the GDPR to the meaningful information about the logic involved. And now you're probably thinking, my God, it's the same thing. But we do not know. Because Article 86 of AI Act, the third paragraph of Article 86 of AI Act, states that the right to explanation from Article 86 of the AI Act shall apply only to the extent that the right to explanation is not otherwise provided for under union law. And the Court of Justice is currently deciding in the pending Dunn and Bradstreet case, precisely on the question whether the right from the GDPR to obtain the meaningful information about the logic involved actually means the right to explanation or not. According to the Advocate General, Richard de Latour, this right includes information that must enable the data subject to exercise the rights from the GDPR, and that information must enable the person to verify its accuracy and cause a link between, on the one hand, the method and criteria used, and on the other hand, the result arrived at by the automated decision. If the court follows this interpretation in its judgment and establishes the right to explanation in the GDPR, something that many of us have argued for years that the court should do, this might actually considerably limit the scope of application of the right to explanation in AI Act, because both rights cannot be applied simultaneously. Moreover, the interpretation that the court will give to the right from the GDPR in the Dunn and Bradstreet case might also have an impact on the interpretation of the right to explanation from the AI Act. Because it seems to me that it is quite important that both rights are interpreted in the same way. And this is because this coherence is very important, because the conditions for application of both rights are different. While, as we could see, the right to explanation from the AI Act only applies in case of high-risk AI systems, on the other hand, the right to explanation from the GDPR applies when a decision is based solely on automated processing. So in Sarah's case, that could practically mean that given the fact that the university exclusively relied on the GENASMUS system, so there was no other human decision maker that was involved in that decision, that decision was based solely on automated processing within the meaning of Article 22 of the GDPR. And that would mean that Sarah could actually rely, or has to actually rely, on the right from the GDPR and not on the right from the AI Act. But if the university adds human intervention at the end of the decision-making process, so if there is a human in the loop, a professor, somebody from the university that revises that from a human perspective and checks whether that decision is correct, then that means that the decision is no longer based solely on automated processing, and that also means that the right from the GDPR no longer applies, but instead the right to explanation from the AI Act applies. And therefore, it would perhaps be more appropriate, or at least easier for legal practitioners, that the legislator would provide in the future only one right to explanation that is regulated in only one legal act. But the opinion of the Advocate General in the Dunn and Bradstreet case is important also in another respect. The Advocate General proposes that the explanation should establish a causal link between the criteria and the result of the automated decision. In that respect, the opinion seems to go further than the current state-of-the-art of computer science, of explainable AI. Now, I'm obviously not a computer scientist. Not only I don't serve, but I'm also not a computer scientist. But if my understanding is correct, then explainable AI is currently only able to detect correlations but not causations between different factors in decision-making. And therefore, it is quite important that the court, when deciding the case, takes into account the level of explainability that is achievable in the field of computer science. I will now turn to the question on how the scope and the content of the right to explanation can impact an effective enforcement of the fundamental right to non-discrimination. And as a background, allow me to recall that AI-based decisions could amount to two different types of discriminations. The first is direct discrimination, the classic discrimination. Article 21 of the EU Charter of Fundamental Rights prohibits, for example, discrimination on the basis of nationality, age, race, gender, or languages. The second type of discrimination is indirect discrimination, which is equally prohibited by EU law, but gets a somewhat different spin in the context of AI-based decisions. Indirect discrimination that stems from an AI-based decision can occur even if a system is programmed not to take a decision based on a protected characteristic. So the system is programmed not to take a decision based on nationality, based on gender, or based on age. But it could happen that the system actually starts taking a decision on a characteristic that is a proxy of a protected attribute. So for example, in an Erasmus application, the number of the foreign languages that somebody speaks, which is not actually a protected category, could correlate with the nationality and could therefore amount to an indirect discrimination based on nationality. It is important to note also that the justifications for these two types of discriminations are different. Direct discrimination can only be justified on limited grounds that are specifically provided for by legislation, whereas indirect discrimination can potentially be justified with any legitimate aim, provided that the limitation is proportionate. And that's why it's quite important to know which type of discrimination we are talking about. Let us now see which type of explanation could help us detect potential discrimination in Sarah's case. Let us assume that the error of incorrect input data was corrected and that the Genasmus system, and again, this is a solely AI-based decision, took into account also Sarah's knowledge of Slovenian language. But nevertheless, her application was rejected. In this case, the first type of explanation could be because you only speak 2 foreign languages, English and Slovenian, you were not accepted for the Erasmus exchange. And we can see from this explanation immediately that there is something wrong in this Genasmus system, that something doesn't work right, because Erasmus programs in Slovenia are taught either in English or Slovenian. So there's logically something that doesn't work. But we can also see that this type of explanation is insufficient to see what is wrong. It is insufficient for the enforcement of the fundamental right to non-discrimination, because it doesn't give us any insights into the interactions between different variables. Now, let's look into the second type of explanation. The second type of explanation focuses on correlations between different variables. And imagine that this explanation gives us the following information. If you spoke 3 to 4 languages, you would have been chosen for the Erasmus exchange, so sort of a counterfactual explanation. And suppose that there is an additional explanation to that, how the AI system came to that. So suppose that you would get the following information. The AI system was trained on data from Erasmus applicants in Belgium, Netherlands, and Luxembourg. Certain from those students, especially students from Luxembourg, spoke 3 to 4 foreign languages. And given that these students were usually admitted for an Erasmus exchange, the system identified during the self-learning training phase a correlation between the knowledge of 3 to 4 foreign languages and a higher likelihood of selection for an Erasmus exchange. What is the impact of this on the enforcement of the fundamental right to non-discrimination? We can see that this explanation establishes a correlation between the number of languages spoken and the acceptance to the Erasmus program. And that could allow us to see that the system amounts to an indirect discrimination based on nationality. The number of languages spoken is a proxy for Luxembourgish nationality. And therefore, the system seems to display an indirect bias in favor of this nationality and hence indirectly discriminates against students from other nationalities. The third type of explanation, focusing on interdependence between variables, could look something like this. If you spoke French, German, and English as foreign languages, you would have been chosen for the Erasmus exchange. And the following explanation could have been attached to that. The AI system was trained on data from Erasmus applicants from Belgium, Netherlands, and Luxembourg, and certain students from those countries, especially from Luxembourg, spoke French, German, and English as foreign languages. Given that these students were usually admitted for an Erasmus exchange, in the self-learning phase, the system awarded higher weights to the combination of these 3 languages, as opposed to other language combinations. And again, what is the impact of this type of explanation on the enforcement of the fundamental right to non-discrimination? By analyzing this explanation, the system could be seen as potentially leading to 2 different types of discrimination. On the one hand, there could be a direct discrimination based on languages, which could be justified only on grounds that are specifically provided in the legislation. On the other hand, there could also be an indirect discrimination based on nationality, because the combination of 3 languages, English, French, and German, would correlate with Luxembourgish nationality and would give preference to these candidates compared to other candidates. So this type of discrimination could be justified in a broader array of grounds. As we can see, for the enforcement of the fundamental right to non-discrimination, we would need a more detailed explanation than in the case of data protection. Now, my example, I admit, is a little bit laboratory, because I know which rights I want to focus on, and I know which rights I would like to enforce. But what if we didn't know what we were searching for? Or if the explanation would prejudge the outcome of the legal analysis, such as the explanation Sarah was discriminated because she is Spanish, could we actually rely on such an explanation to determine that Maastricht University discriminated against Sarah? I don't think so. I think we would need to look a little bit deeper. And I believe that these questions need further doctrinal, empirical, and interdisciplinary research. So let us come back to Sarah now. I would like to ask her, Sarah, did this advice help you? Once she speaks when she's not invited, and now she disappears.
Thanks for the advice, Maja. While you were busy lecturing, I have already sent an email to Maastricht University, and they replied that they reviewed my application manually, without the help of Genasmus, and that I am admitted to my Erasmus exchange. I can start in January 2025.
That is great news, Sarah. Congratulations.
Thank you. I am very happy. I can't wait to visit Bled, Ljubljana, and the oldest grapevine in the world, which is in Maribor. But let me focus on my research first. Are there any interesting topics in the field of impact of new technologies on courts that I could address?
Of course. From the top of my head, I can think of 3 potential issues that would deserve further research in the upcoming years. All 3 of them are linked to the question on how the scope and the content of the right to explanation can impact the fundamental right to effective judicial protection. The first issue is quite straightforward. It would be interesting to collect empirical data about the types of explanations that the administrative authorities give to citizens when they use AI in decision-making. And then in collaboration with computer scientists, you could clarify or classify these different explanations into categories and then use data mining to determine to what extent one or the other type of explanation enables or prevents to bring a claim in front of the courts. The second interesting question with regard to explanations and access to justice can also arise from court cases regarding claim for damages against the producers of AI systems. So Maastricht University could file a legal action against the producer of the Genasmus systems, because you can imagine that Maastricht University, if it took its decision manually, would never discriminate against Sarah. And in that potential legal proceedings, the court would need to apply the new Product Liability Directive that has been adopted or changed in October 2024, so just about a month ago. In that Product Liability Directive, there is a presumption of a causal link between the effectiveness of an AI system and the damage occurred. So the national judge that would be deciding that would be actually facing that presumption, but that presumption can be rebutted by the defendant, so by the producer of the Genasmus system, and then within that rebutting of the presumption, the producer will probably need to explain the functioning and outputs of the AI systems to the court. And here the question arises, how will the court verify the veracity of such explanations submitted by the producer? The third question that I find interesting both as an academic and as a judge is linked to the review of legality of AI-based decisions taken by European administration. Let us suppose that in the future, the European Commission puts in place an AI-based system to award contracts through its calls for tenders. Such an AI system could be trained to choose the best offer based on predetermined criteria. And suppose also that there is a claimant coming in front of the General Court of the EU, claiming that the system is discriminatory and that that claimant should have been chosen by the system. In order to decide that question, I'm wondering which standard of judicial review should the EU General Court apply when deciding a case like that? Should that be a limited review, just like we do with complex scientific or economic data? Should it be a normal review, just as if the Commission hasn't taken help from the AI? Or should we have unlimited jurisdiction, a review de novo, which gives the court the power to alter the decisions of the administrative authority, just as we do in trademarks or competition law fines? And I believe that there are strong arguments in favor of each of the 3 options, and this is certainly a topic for my research agenda for the future, and who knows, perhaps also sooner or later on my desk as a judge. To conclude this lecture, and also as a food for thought for future research, I will also focus on the question whether, given the importance for the enforcement of fundamental rights, should the right to explanation in itself be recognized as a fundamental right? And again, there are good arguments in favor and against of answering to that question. But this is a topic for another occasion and for another lecture in the future. To conclude this lecture, and I would just like to quote Eliezer Yudkowsky, with whom I actually agree, when he said, "By far, the greatest danger of artificial intelligence is that people conclude too early that they understand it." Now, it is customary at Maastricht University to continue with words of thanks. And however, in the interest of data protection of those that I would like to thank, I would like to say these words in camera, without the live stream. So before turning to that part of the lecture, I would therefore like to thank very much to all of the colleagues that have been present online via live stream. Thank you very much for your presence online and for your support. And Sarah would also like to say a final word.
Thank you also from my part, and I hope to see you soon.